Hello again. Remember, I'm not a professional. I'm just concerned that people without the public school education, let's put it that way, um, don't fully understand how they have themselves, through their own consent and contract, bound themselves up in a way that gives the state a lot of power to regulate their lives. In my previous video, I talked about a legal term called parens patriae, and I read some quotes, and I just wanted to refresh your memory that, under the doctrine of parens patriae, I'll just do this last one again. In other words, the state is the father and mother of the child, and the natural parents are not entitled to custody, except upon the state's beneficent recognition that natural parents, presumably, will be the best of its citizens to delegate its custodial powers. The law devolves the custody of infant children upon their parents, not so much upon the ground of natural right in the latter, as because the interest of the children and the good of the public will, as a general rule, be thereby promoted. And remember, too, I pointed out that some families down in Texas back in 1986 asked the AG, and they all had state-issued birth certificates. They all had state-issued marriage licenses. They were 14th Amendment federal citizens, and they had Social Security numbers, etc. And this was the Texas AG, Jim Maddox. And they asked him, is it true that the state of Texas owns our children? And the Attorney General, Jim Maddox, replied, yes, it's true. And not only your children, but you too. Now that brings us to why I want to talk about today. Another problem that Americans have is property, and actually property ownership. And that's changed. Their title to property over the years has changed, not only because of their status under parens patriae, but because they don't ever pay any debts at law. Now, before we get to that one, let's go to, I've got some quotes here on banking, just so that we can see this. Before we read these, though, just think about this, ponder this question. Can you pay a debt with more debt? So is that really payment, or is that something else that we think is payment? We say I pay it, but it's really not a payment. It's what they call legally a discharge, because you can't really pay debt with more debt. And the banking system is all monetized debt. We're off a gold and silver standard. Biblically, and under natural law, and even the previous common law before it kind of got abandoned and corrupted so bad, you had to use substance out of the earth to pay debts. And even the Constitution of the United States says at Article 1, Section 10, no state shall, ... and it lists off some things. And one of them is, make anything but gold or silver coin a tender in payment of debt. Now, when was the last time you used a gold or silver coin to pay a debt? You haven't. Most Americans alive today have never even touched gold or silver, other than maybe in some silverware or jewelry. But they certainly haven't touched a gold or silver coin. Now, that doesn't mean everybody. I'm just saying the majority of them use pieces of paper, which say right on their face that it's a note, a bill. What is a bill? Something you owe. What's a note? A promissory note. I mean, look at this dollar bill here. What does it say right at the top? The very first thing, even above the United States, it tells you whose note this is. The Federal Reserve's note. Now, this is legal tender. You can use this to discharge debts, but you're not really paying a debt. So that means that you can't really own the property to the absolute dominion of another party. Now, do your children, because of parens patriae, do your children, minor children living under your roof, do they really own anything? If your teenage son, 16-year-old son borrows your car, does he own the car? Or is he just using your car and you're the responsible party that has the title to use and possess that car? Does your son own his bed and his dresser and all that stuff in the house, or do you own it? Now, you could give it to him when he moves out, or your daughter when she moves out of the house. You could give it to him, but they don't own it. You have a title to it to be able to use and possess that. And we'll talk about these different titles because that's really what people have. My cat wants to get involved here. Mia, you going to tell him? You going to tell him all about banking? So let's look at these and we'll see see if I'm pulling your leg. Here, this first one, because it's no longer under natural common law, it says the entire taxing and monetary systems are hereby placed under the UCC, which is the Uniform Commercial Code, Federal Tax Lien Act of 1966. The court in Minnesota said this: there is a distinction between a debt discharged and a debt paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. Something of the original vitality of the debt continues to exist, which may be transferred, I think I typed that up wrong, misspelled, even though the transferee takes it subject to the disability incident to the discharge. Now, that was from Stanek versus White. And then we go on. Here's the Federal Reserve actually telling us something. Every circulating Federal Reserve note, that's what that FRN is, Federal Reserve note, which I just had in my hand a few seconds ago, represents $1 debt. What? Debt to the Federal Reserve System. So who do you owe that debt to? The Federal Reserve. And that's from Modern Money, Money Facts, House Banking and Currency Committee. I'm sorry, that wasn't from the Federal Reserve. So here's one from the Roger Hemphill from the Atlanta Federal Reserve Bank. We are completely dependent, another misspelling there, on the commercial banks. Someone has to borrow every dollar we have in circulation, cash or credit. What? Someone has to borrow every dollar we have in circulation, cash or credit. If banks create ample synthetic money, what? Synthetic money? We are prosperous. If not, we starve. We are absolutely without a permanent money system. It is the most important subject intelligence persons can investigate and reflect upon. It is so important that our present civilization may collapse. I think we're getting close, unless it becomes widely understood and the defects remedied very soon. And that's, again, Roger Hemphill. Now, what I did put in here, remember, anything in brackets are my little editorial comments. From 1933 up to 1986, I think. It's either 83 or 86. I can't remember exactly, so don't hammer me on that. But the U.S. Mint, gold and silver was not really in circulation. That was minted by the U.S. Mint. Now, you could use gold bullion. You could use foreign gold coin. I've been using gold coin and silver coin as well as many other forms of substance. Anything out of the earth is substance that can be used as the reciprocity or consideration in a private natural law business transaction. But if you use these other forms of payment, checks, bills, credit, even crypto, people are concerned, thinking crypto is going to be their savior. No, that's a commercial. That's going to be under the commercial law. That's not going to be under natural law, because crypto is not substance out of the earth. It is digital, and it requires electricity. And once electricity isn't available, what happens to all that crypto? You're kind of SOL. So here I put, this isn't exactly true, because the United States did start minting gold and silver coin again. So you do have that available to you to use, but here's the caveat. That gold and silver that's today has already been hypothecated as collateral on the debt.
So it's even though I put that in there, you do have a dual money system. You have all the paper stuff, the commercial law stuff, and you also have substance. But always keep in mind that that substance now, if it says United States on it, is collateral on the debt, just like everything else. Everything else that's ever been bought and paid for with a Federal Reserve note or check or credit card or loan, all of that has been hypothecated, remember, because every circulating Federal Reserve note represents a $1 debt to the Federal Reserve System. Well, the Federal Reserve bankers are not going to just let you have that for free now. That's going to divide the title. And that's what happens. This is the same thing that happened to the Israelites when they went into Egypt. It was a division of title between legal and equitable, and the Pharaoh got the equitable title. The legal title went to the Israelites, and now they had to pay an income tax on everything they earned. They had to pay all kinds of tribute. That's what all excise taxes are, is tribute to a master, a superior. Any form of excise, whether it's gasoline tax, sales tax, income tax, property tax on your real property like your house, all of that is tribute because you don't really own it. It's more like serfdom. You have a legal title to possess and use it, but use must be in accordance with the civil law of the state because the civil state owns you and the bank has an interest because you use the bank's note. If I used your note to go buy something, would you have an interest in that ownership if I used your note, your IOU? Of course you would. I can't pay a debt with debt. And if I use your debt, if I obligate you through your freely choosing to issue a note to me to use your IOU and somebody accepts it as a discharge or what we call payment, even though it's not really paying, you have an interest in that, or you should, and so does the bank. So the state has an interest because the state owns you under parens patriae. The bank has an interest in that property because you never paid for it. And people say, would I use my labor? Well, you pledged your labor to enter into the stream of commerce as an employee, and what were you paid with? Federal Reserve notes. So your labor, and that's income. When you're engaged in the stream of commerce for a corporate entity, whether that commercial business entity is a corporation, an LLC, oops, I think my screen just went dead because I wasn't playing around with it long enough. Sorry about that. So if you work for any licensed commercial business entity operating in the stream of commerce, that's income, kids. That's income. You're being paid a share of the profit and gain derived from the stream of commerce, and that's income. Now, property, on the other hand, is not taxed, but income is. Income is derived from property. It's not the property itself. So let's go on here. Neither paper currency nor deposits have any value as commodities. Remember, things that come out of the earth. Intrinsically, a dollar bill is just a piece of paper. Deposits are merely book entries. And then here we go. This is a biggie. This is from Charles Lindbergh. He was a senator, U.S. senator from Minnesota. His son was the famous pilot. This is the father. This Federal Reserve Act establishes the most gigantic trust on earth. When the President Wilson, signs this bill, the invisible government of the monetary power will be legalized. The worst legislative crime of the ages is perpetuated by this banking and currency bill. So what that trust is it's a giant, it really is. The Federal Reserve is a giant, we could call it a cesti public eleemosynary trust. It's kind of a public religious trust. It's what's helping to keep the body politic, the corporation called United States, and all of its corporate members called 14th Amendment citizens afloat. So all of this stuff, everything, and this is the little note I meant. So your chattel property, your clothes, your refrigerator, your lawnmower, your labor, real property, like your house, cars and stuff would be chattels. So real property would be like real estate. Is discharged with Federal Reserve monetized debt, is the corpus of the trust and represents the collateral on the debt. Oh, That's why they called in the gold and silver in 1933, in March of 1933. That was the first calling in of collateral. Okay? Now, keep in mind, I put a little note here, bank accounts, mortgages, credit cards are all voluntary. And when you sign those contracts, when you sign that checking account signature card, you're agreeing to obey all the rules of the bank and the Internal Revenue Code, blah, 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 blah. There is another way, which is mandated in the common and natural law, even the U.S. Constitution at Article 1, Section 10, gold and silver coin and other substance as consideration, paying debts at law. This is natural law, common law, not discharging debts with commercial paper in civil law, UCC, equity, maritime law, that commercial law. You don't own stuff then. Now, let me prove it to you. What happened, let's go here. This is back, again, when they called in the gold and silver, that was in March of 1933. Now, this was issued by the U.S. Senate in April of 1933. This is found in the 73rd Congress, first session, Senate document number 43. And basically what happened is the U.S. corporation declared bankruptcy. During the Great Depression, just about all civil law government corporations, these body politics, declared bankruptcy because they were in debt. Now look at what happens when you start discharging debts with this Federal Reserve funny money. The ultimate ownership of all property is in the state. What? That's the first plank of the Communist Manifesto. The ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. the civil law, amounting to mere user. And use must be in accordance with the civil law and subordinate to the necessities of the state. Now, actually, this covers every form of law. Because in the Ten Commandments, you can't covet and you can't steal. Now, you never paid the debt. You thought you were paying the debt, but you didn't. You discharged it. So you don't really own it because you didn't really pay that debt. So the titles are split, and that's what I'm saying down here. Legal title. This is from Black's Law Dictionary. One cognizable and enforceable in a court of law, or one which is complete and perfect. Now, be careful here. Oh, well, complete and perfect sounds pretty good. So far as regards the right of apparent right of ownership and possession, user, but carries no beneficial interest in the property. Another person, the state or central bank in this case, being equitably entitled thereto. In either case, the antithesis of equitable title, it may mean appearance of title as distinguished from complete title, which we used to call a lodial or a lodium in the United States, which we still do, but nobody owns property that way. Full and absolute title or apparent right of ownership with beneficial and equitable title in another, not necessarily record title. A tax title, which is prima facie valid, is a legal title. So again, you have the title. It's kind of like if you go and rent the Hertz car. You might say, the rental car, when it's in your possession and your use, you say, well, that's my car. Well, yeah, it is to a degree. You have an equitable interest in that car during the duration of the contract, right? As long as you obey the terms and conditions of the contract, the law between you and Hertz, and you obey the laws of the state, because Hertz doesn't even own that car. Hertz is an artificial person that never paid for that car either, so the state and the central bank are the higher owners of the Hertz car. So Hertz has to obey all the rules in accordance with the law, like registration, because you don't own it. That's why you have to register that property. That's why you have to get a license. Remember, license from yesterday. License is permission to do something from competent authority that if you didn't have that license, would cause you to do something illegal, a trespass, or a tort. Well, can you use your neighbor's lawnmower without your neighbor's permission? If you do, if you don't get his permission, his license to use his lawnmower that he has the title to possess and use, that's called stealing. So you do kind of own it, but it's a split ownership interest. You don't have absolute ownership to do with it what you will. Now, I'll give you a good example of this. If you really think you own your house
do two things. Stop paying property tax on it. If you really own it, you don't have to pay for it. Or go burn your house down, because if you really owned it, you could burn your house down and build another one. But if you try to burn the state's house down, the bank's house down, because you just have the mere legal title and you're paying a tribute on that every year in the form of what you call property tax, to keep that your legal title in good standing. Remember, you're just a user, and you got to keep all the laws of the state to keep that use in good standing. So if you don't pay those, try not registering your car, don't get a driver's license, see what happens to that car, because it's not yours, and you don't even own the road. The state owns the car, the state owns the road. So burn your house down, see what happens. You're going to be arrested for arson because you don't really own that house. You try driving a car without a license and without on the state's roads, financed by debt, and you're going to see who really owns that car. And that should be an indicator, but most people are they don't understand these concepts, So, and now look what happened. We used to be allodial. I put these in here. Allodial. These are again from Black's Law Dictionary. Allodial, free, not holden of any lord, i.e. master, or superior, like the state or the fifth plank central bank, the Federal Reserve. Owned without obligation of vassalage or fealty. Ooh, that's like excise taxes. That's like your property tax. That's your registration, your license. Those are obligations of fealty and vassalage. You're an inferior to the superior, and you don't own it outright. So you got to do what your lord and master says to do. So allodial is the opposite of feudal. Well, that's another way of saying it. You're now back to a neo-feudal serfdom, but you believe you're free. Like Goethe, the German philosopher Goethe said, none are more hopelessly enslaved than those who falsely believe they're free. Allodium, land held absolutely in one's own right and not of any lord or superior, like the state, central bank, remember under parens patriae, and the fact that you're using Federal Reserve credit to discharge your debts, you can't really own anything in allodium. Land not subject to feudal duties. So again, taxes, easements, assessments, registration, etc., permits, building permits, or burdens, permits, licenses, codes, use statutes, etc. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Now, Americans used to own property in allodium a long time ago. They don't anymore. Those titles have been split.